Welcome everyone to INTA's Young Practitioners panel discussion on how to win unwinnable cases, mastering the art of overcoming the impossible office action. As this is an INTA event, I'm going to be starting off by discussing some of the benefits of membership with INTA. INTA is a global not-for-profit advocacy association consisting of brand owners and professionals dedicated to supporting trademarks and related IP rights to foster consumer trust, economic growth, and innovation. INTA is engaged in a lot of different types of activities. So, for example, they can act as third-party interveners for Canadian Supreme Court of Canada cases or act as amicus curiae. They can also do a lot of work with online courses where there's substantive learning, such as this one, or also a lot of various networking activities. There are lots of benefits to membership as well. For example, there's the INTA Bulletin, the Trademark Reporter, Global Reporter. You can get access to checklists, country guides, which are really helpful when you're trying to understand how prosecution occurs in other countries. And of course, there are events. There's the annual meeting that most people are aware of, where about 13,000 INTA members descend upon a city somewhere in the world to have a couple of days of extensive networking and substantive content sharing. There's the leadership meeting and various roundtables and regional conferences. How do you join? It's pretty straightforward. You can go onto the INTA website and create an account. And from there, you can also learn about the various committees and volunteer to assist there. So in short, on behalf of YPC, I encourage you to consider joining INTA and certainly consider being a committee member. So without further ado, I'll get straight into introductions. First up, we have Winnie Chen. She is a partner at Bereskin & Parr in Toronto, Canada. Her practice focuses primarily on trademark prosecution, IP licensing, and associated litigation. She has significant experience in managing global trademark portfolios, and she brings to the table an international perspective, having worked in 3 different continents, gaining various legal and business experience. And she sits on the INTA Internet Committee. Next up, we have Dana Dixon. She started out as a trademark examining attorney at the USPTO and has since founded her own firm in Atlanta that primarily focuses in devising strategies to help her clients get their mark through to registration and maintaining it there. As a former USPTO examining attorney, she therefore is in the very enviable position of having that sixth sense of how examiners might react. So while this panel is focused on Canada, her contributions will help us understand another jurisdiction that is close to home and hopefully spark some ideas of a refreshing way to approach universal examination issues. Last, but certainly not least, we have David Bowden, who is an associate at Clark Wilson LLP in Vancouver. Prior to joining Clark Wilson, David worked for 2 IP boutiques in Toronto. The majority of his practice is in the field of trademarks and has been since he was called back in 2013. Since his first role as a summer student in 2015, David's work has regularly involved reviewing examiners' reports, developing strategies for response, and drafting the responses themselves. He sits also with the INTA YPC committee. My name is Christy Bates. I am a trademark agent and lawyer at Castles, Brock & Blackwell in Toronto. My practice spans trademark and copyright work and is centered on licensing, protection, enforcement, and acquisition of IP. I am intimately familiar with the feeling you get when a seemingly impossible office action lands on your plate, but at the same time, there are a few sweeter moments in my career when I nonetheless managed to get the mark registered. So without further ado, again, I'm very pleased to get into the substantive portion of this talk. The discussion is organized around the life cycle of a trademark, so we'll be starting at the application stage. So Winnie, to start off with, are there any strategies you can implement at the application stage to decrease the likelihood of an office action?
Thanks, Christy. Yeah, certainly. While we try to do our best to avoid office actions, I think it's hard to construct a truly bulletproof application that can guarantee a client that it won't be, examined and objections will be raised. And that's simply because, trademark practice changes over time and examiners are highly unpredictable. But there are certainly ways that you can try to at least minimize or reduce your chances of getting objections At least with technical objections, I would say, try to use the goods and services manual. You can at least significantly reduce your chances of getting objections to the description of goods and services if you only include pre-approved terms listed in the manual. And the manual, of course, is available for everyone to use. It's online. If it's not possible to use the identical terms, then you can at least try to follow the wording that's in the manual and amend as you see fit. Or you can try to look at other applications that include language that would be fitting for your application and that have been recently approved. If you're going to file for a design mark that's in color, the Trademarks Office will require you to describe and claim color as a feature of the mark. And so during filing, you can describe the color claim to avoid that technical objection. And if you're going to be filing a mark that includes any words in any other language besides English or French, or words in another alphabet or in a different script, you can insert translations and transliterations of the marks during filing. Now, the good news is that these technical objections are relatively easy to overcome. It's more of the substantive objections that are more difficult to predict. And I would, to that, I would highly recommend, before you actually file, to conduct a trademark search because, you don't want to give your clients the wrong impression or expectation that a mark will go through when it won't because of different obstacles. And so just to highlight, one of those obstacles that may turn out to be a truly unwinnable case, in Canada, we have something called Section 9 or prohibited marks. And these marks are somewhat unique to Canada and they have sweeping protection. And it says that, under the law, no one else is supposed to adopt in connection with the business, trademark, or otherwise any mark consisting of or so nearly resembling a Section 9 mark, unless consent is given by the owner. So these are the type of marks that have been adopted by a public authority, which is usually a government agency, or marks that have been advertised by a university. And so the university doesn't have to be in Canada. It also includes, it includes Olympic rings, most national flags, scandalous, obscene, or immoral words or devices, or marks that falsely suggest a connection with any living individual. And so, a search before filing will help you identify marks that would be an absolute bar to registration, again, unless consent is given.
Yeah, I guess just to add, I'm relatively junior, so often when I get these things, I wasn't involved in the pre-filing process. But I know like a lot of times clients don't want to take some of these steps. Clearance searches are always advisable, but often clients don't want to incur the expense. Or you might simply be dealing with foreign counsel who know what they want. They file the same way in other jurisdictions, and they just want to go ahead and do that. Increasingly in Canada too, sometimes you get Madrid filings where it was initially an extension that you had nothing to do with, and you're appointed after the fact. I wouldn't worry too much. Often you can find something to say, notwithstanding the fact that you weren't able to intervene earlier on. So it's not the end of the world. And I guess we'll discuss some of that later on in the webinar.
And I'll just mention two things. First of all, if you think you are in the presence of a merely descriptive mark, as we call them in the US, or I think you refer to them as clearly descriptive marks here in Canada, then you will definitely want to check your client's website before you file an application. You would be amazed back when I was reviewing applications how very often the best evidence to support this type of refusal came from the applicant's own website. And sometimes I could get 20 screenshots from their website where they are just using this wording over and over again in a merely descriptive manner and not as a source identifier. So check in on that, make sure that your client is not just serving up on a silver platter to that examiner all of this wonderful evidence that they can use against them. The other thing that I will mention is specimens of use. And by that, I just mean these things that you use to prove that the client is using that mark out there in the real world marketplace. And I have learned from Christy recently that this is not something that comes into play in the Canadian application process, but it can be a big problem in the US, and it comes up at two different stages. So first of all, in the application process, if we are putting to one side anything Madrid or Paris related for any other path to registration in the US, you will have to present an acceptable specimen of use before you can reach registration. And then it comes up again in the maintenance and renewal phase. So 5 to 6 years out from registration, you will have to submit a specimen for every class, unless you are very unlucky and you get audited, and then you will have to submit multiple specimens for every class. But either way, specimens will become an issue. And that's true even if you came in under Paris or Madrid. So there are many different types of specimen problems that can pop up. I will just mention one of the most common, which is a specimen matching issue. The USPTO is very particular about this. They want that specimen that is showing that mark to be a substantially exact representation of the mark as it appears in that drawing in the application or registration. And so that means if you have a mark drawing that shows a bird with some wording underneath it, and that's in the application or registration, and you submit a specimen that shows a bird with wording beside it, you will get a specimen matching refusal. So what you want to do in the early stages is just check in with your client, make sure that whatever drawing they sent you and said, excuse me, the pollen is really bad in Atlanta, I apologize. Whatever specimen they have is going to match up with whatever drawing they sent you. So check on their website or check their product packaging and make sure that those things actually look the same. That will save you a big headache later on down the road.
Excellent. Thank you, everyone. So I'll now just note that there will be a pause in the recording. We encountered some technical difficulties while recording this event today. So it will jump to a new session. You are listening to the same session. We just might all be in slightly different places on the film. So we hope you enjoy the rest of this INTA session.
You want to see if the status is still active. If it's in default, you may want to monitor the status of the application because it's possible that it may become abandoned by the time that your final response is due, and taking account to all the available extensions to you. If it's a pending mark that's still held up in examination, you want to check who the filer is. If it looks like it's filed by a serial fraudulent filer such as Brandster Branding, then there's a good chance it may go abandoned. And so maybe at that point you want to try delay responding to the office action, or maybe submit one round of arguments to outlive that cited application.
Excellent, thank you. That was very comprehensive. And I know we'll be going into coexistence agreements now, but David or Dana, do you have anything you'd like to add to Winnie's comments?
I feel like that covered the waterfront, so I'm ready to move on to the next one if you are, David.
Definitely, yeah, very comprehensive. Thank you, Winnie.
Okay, perfect. So Winnie foreshadowed what we'd be discussing next, which is coexistence agreements. So David, I'd love to hear what you have to say about the effectiveness of coexistence agreements and letters of consent, and specifically, do you have a secret sauce?
I wish. I guess this is one of those circumstances where it's highly variable between jurisdictions. So it's worth keeping in mind, because I find an often scenario is, you'll get a mark cited, you'll report it out to foreign instructing counsel, and for instance, they'll say, oh, no problem, we have this letter of consent, and they'll send it through. And it'll just be a simple kind of one sentence, we consent to the registration of this trademark. And I guess, to back up even further for those who aren't aware, one of those options when you receive a confusion citation based on a prior registration or earlier filed application is a letter from the owner of that record saying, oh, not a problem, we don't object to this registration. as Canadian practitioners, it's important to keep in mind that those sort of letters can be very helpful in certain jurisdictions, like almost sufficient to overcome confusion objections, from what I understand from speaking with other practitioners. Unfortunately, that's really not the case in Canada. If you submit a letter of consent that just simply provides that that owner's consent without further argument, or with providing bases on which they believe that confusion is unlikely to occur, you're just going to get another office action that says, mutual consent isn't a basis recognized for overcoming confusion. They'll likely mention the public interest in keeping confusing trademarks from being concurrently used in the marketplace. So that's just worth keeping in mind, both for the detail that you need to include in a letter of consent, and also just to help mitigate your client or instructing counsel's expectations in that regard, because it is different in Canada. I take a relatively pessimistic view overall of the utility of letters of consent in Canada because of the required detail. I get the kind of most recent case we have sets out certain things they need to speak to about differences in the goods, for instance, or particular natures of the marketplace. If the parties coexist in foreign markets, our case law guides that they need to comment on the dimensions of that foreign marketplace, why confusion is unlikely to occur. Generally, when I'm drafting the letter of consent too, I try to describe like a mechanism for identifying confusion in the unlikely event it should arise. But all that's to say, like by the time you're drafting a letter of consent, you're kind of canvassing the issues that you would otherwise be identifying in just a response to the confusion objection in the office action. So really, like letters of consent are likely most useful or most persuasive in situations where you likely could have gotten to the same result in submitting a really persuasive response to an office action. So I generally very pessimistic about their chances for success. That said, I think that there is some sort of persuasive value after submitting an argument. And I usually submit argument in response to a confusion objection, even when I'm submitting a letter of consent. There's like an extra sort of persuasive benefit to tell the examiner, like, okay, this isn't confusing for X, Y, Z reason. And also, if you have any residual concerns, look, this is the owner of the mark in question, and they don't take any issue. I think that there is, notwithstanding the fact that there isn't a good legal basis to use them in Canada, there's an obvious persuasive benefit. But yeah, that's my 2 cents on that.
Winnie and Dana, anything to add?
Yeah, I agree. So, sorry.
That's okay. Go ahead.
I agree with David completely. If there can be a combined strategy where you're filing a response and filing consent agreement, or even, use other strategies such as, amending the statement of goods and services to specify the channels of trade and file the detailed consent agreement, I think there may be a chance that, the examiner will be persuaded to withdraw the objection. But I think it's important to also look at the examination manual, because it does give a little bit of guidance as to the types of information that they consider relevant in a consent agreement. And so, that includes, that the parties realize there's no actual confusion in the marketplace. They're going to take necessary steps to avoid confusion. And so if you can get that in a detailed letter, you can maybe tell the client, like, your chances would be improved, versus a letter that just has like one line saying I consent.
And I'll just give the US perspective very quickly, which is, as an examiner, I loved when I got a good consent agreement, and I was happy to be able to let go of that refusal. So it can be very effective in the US, but we do need something similar to what you were describing. It cannot just be this one sentence statement, hey, the owners don't have any problem. We would call agreements like that naked consents. I don't know if you say that in Canada, but basically you do have to have something in there that's a reasoned assessment of the marketplace, meaning, this is why we don't think it's going to be likely to cause any confusion. Here are the steps we're going to take to prevent confusion. If confusion does arise, these are the steps we're going to take to address that. And basically, when you think about the underlying policy reasons for trademark law, we want to protect the consumer as well as the mark owner. And so the USPTO is not going to be satisfied with just, hey, we don't have any problem with it as the owners. You need to have something in there that gives them some level of comfort that you took consumers into consideration and you are not going to just let them be misled completely. So sounds kind of similar, maybe not quite such a high standard as what you have in Canada, but it does need to be something that shows consumers won't be negatively impacted.
So Dana, on the point of persuading examiners, when do you pick up the phone to call examiners? Do you find it's helpful to do it as a first step, somewhat later throughout the process, repeated calls? Your strategy would be appreciated.
Anytime that it is going to save time. So if we have the prospect of an examiner's amendment, absolutely, I will get on the phone. If there's anything that I am confused about in that office action, I will get on the phone to get clarification. And you have to understand these office actions are drafted, under extreme time pressure. These are not novels that have been submitted to multiple rounds of edits and revision. So that examining attorney may have a really wonderful set of reasons why they did what they did that don't always come through with crystal clarity in what they wrote you. So sometimes it is very helpful and time saving just to get on the phone and, politely ask for some clarification. Say something like, I just want to make sure I understand where you're coming from so that I can give you what you need to feel good about moving forward with this. There are other situations where maybe they have made a mistake. They are human, and so that can happen. And if it does, that's a little bit trickier to say whether you pick up the phone and make that call. What it really comes down to for me is, will talking about this on the phone be a quicker and easier route to resolving it than talking about it through email or just by filing a response? And can we do this in a non-alienating way? Can you do it with humility and humanity? If so, great, have that phone call. If not, better to put it into writing. But that will come down to each person's own approach to this job. I personally think the phone call is not the time for a mini hearing, a mini trial, and certainly not to vent the frustrations that you have with that examining attorney. It's a time to talk about anything that can possibly push this process forward. So if you think there's room for collaboration and dialogue, absolutely make the call. If not, just don't do it.
Excellent.
I think that's especially for young practitioners, that's a very important point. If you're going to call an examiner, under no means be nice to that person. Be as nice as possible to that person. And I've got, you get office actions where the trademark isn't identified, where there's copy paste errors. It doesn't matter. Be as nice as possible to that person. There's no benefit at all to being mean. I would say my tip is like a young practitioner. What I wish I would have done, like early on, is like start a spreadsheet, maintain notes, write down the name of every examiner you call, and just sort of like meta notes, whether or not they were helpful, whether or not they just repeated. Like sometimes you talk to an examiner, they just repeat examination manual text back to you, whether or not it's responsive to what you're asking. Those probably aren't helpful. They're people, right? They're people who work under in these weird situations. And if you start like a comprehensive set of notes, it's actually possible to get, a good idea of the people who work there and whether or not some are helpful for clarifications or not. And when you're suddenly 5, 6, 7, 8 years in, you're trying to I sort of remember that examiner, but I don't quite. You don't want to be in that position. So if you're starting off, you have a real advantage to just start that document now. Just write notes down about it.
Yeah, I think over time you come to realize who truly are the tough examiners. As soon as I get an office action by somebody that last name starts with a B, I'd be like, okay, this one's gonna die. No, but seriously, I personally would pick up the phone, whenever I think there is unclarity. When the office action doesn't really give me an understanding as to why they're raising it in the first place. If they say that a mark is confusing with another mark, but they don't really specify what goods and services are objectionable, then I may at that point, call the examiner just to get further clarity and say, is it all the goods and services that are listed in the application or just like a subset? So And then, if I'm filing affidavits of distinctiveness, I may call the examiner just to ask, what's wrong with my evidence if they don't really spell it out in the office action. Or maybe, can the examiner give me some pointers? The examiner is always going to say to you that any comments over the phone are not binding, but at least you'll get an understanding as to the position that they're taking and whether it's absolute or whether there could be like a small chance that you're able to get it through another response.
Thank you. And it's possible that this question has already been covered. So if we want to move on to the next one, we can certainly do that. But Dana, again, because you were on the receiving end of so many of these calls, did you find anything particularly effective in terms of how to, when attorneys were calling you to organize their calls or to put forward their case? You referenced that it's not meant to be a trial. So for example, is it appropriate to bring up case law on the call, or is that something that you think is better served in the written argument?
Okay, well, first of all, if you bother to organize yourself before that call, you will be ahead of a lot of other attorneys. And you will have the undying gratitude of that examining attorney as well. If you don't bother to organize yourself, you will have their deep resentment. So the choice is yours. I would say, definitely have anything pulled up on your computer that you will want to reference during that conversation before you make that call. This is not a time to be shuffling around papers and saying, oh, what was it I wanted to ask you? I had one more thing. No, please have an outline. You don't need to have like a brief written up. It's not oral argument. Just have an outline of the topics that you want to cover and the questions that you want to ask. And then I will tell you exactly what would have been my ideal phone call back in the day. You call up, you identify yourself. You give the serial numbers for any files that you want to talk about, okay? And then you say, do you have time to talk about this with me? Great, thank you so much. I will give you a moment to pull that up. You just let me know when you're ready. Okay, now then you become quiet. Please, this is so important. And it seems simple, but here's the thing, like they do not automatically remember off the top of their heads exactly every detail of your file. It's fresh in your mind. It is not fresh in their mind. They are dealing with a really large volume of applications. So they need time to pull that up and scroll through it and remind themselves, okay, what were the issues here? Why did I think that was a problem? Now I'm ready to engage, all right? And you want to let them do that because if you instead just launch into whatever it was that you wanted to talk about, you will not have their full attention. They will still be reading through that document, trying to remember what it was about. And you want their full attention. So just give them a moment. And then you want to give them some idea of where you're headed. I have 3 questions that I would love to go over if we have time. Great, okay. Now address your points, because then they know this is not gonna be like a 30-minute phone call, or this is not gonna be 30 questions. We've got 3, then I'm done, I'm back to my work. And then go through whatever it is that you want to ask about, and then thank them for their time and hang up. It's really straightforward. It's really simple. You can bring up case law. You ask Christy, can I bring up case law? Yeah, absolutely. You can do that. They are probably going to want to take a look at that before they get back to you. And they will probably not take a look at that while they are on the phone with you. So just have that expectation that, whatever you give them, if it's a section of the manual or a case to look at, they will probably say, okay, well, thank you. And I will take that into consideration and I'll follow up with you. They're not going to read it on the phone with you.
Thank you. That's really helpful. And I think I think it's always helpful for young practitioners to take a moment to breathe before you call examiners. You can often have a lot on your plate, and if you haven't done it a lot, you won't necessarily know how to approach it. But I think the trick is to take the time, organize it. Someone actually sent me a message in the chat saying you should be treating examiners like you would a client. And I actually think that is quite insightful. And ultimately they have the power to make it happen or not. So I think, and it's not that the examiner is out to get you. I think sometimes you can look at an examiner as opposing counsel, but that's not a right way to view it. So they're on your side, and help them get to the conclusion that you want as much as possible. So we're now at the money question. So when faced with an inherent distinctiveness objection, what is your plan of action?
I'll start off, Christy. I think it's safe to say that, not inherently distinctiveness objections have become a thorn on our side ever since 2019. When deciding whether a mark is inherently distinctive or not, the examiner will usually question, is this a mark that other traders should be able to use with the same goods and services? So if the answer is yes, then they'll likely take the preliminary view that the mark is not inherently distinctive and raise the objection. But before raising it, the examiners could also go, and more likely will go through the examination manual and see the different examples that the registrar has deemed to be not inherently distinctive, and see if your mark fits into one of those categories. And so the list is fairly long, and it's all in the examination manual, but they include marks such as those that have primarily merely a name or surname, marks that are clearly descriptive, marks that are primarily a geographic location, generic design marks that are not fanciful or special, 2 or 1 letter or number word marks, and the list goes on and on. So, what's my plan of action? How do I respond? Well, the examiner usually gives you 2 options in its examiner's report. And they say, you can file evidence of acquired distinctiveness as of the Canadian filing date, or you can provide a comment as to why you consider the mark to be inherently distinctive. And so, if you're going to file arguments, I would say go back to the wording of the Trademarks Act and look at the Trademarks Examination Manual and see that, the term not inherently distinctive, it refers to a mark that has no inherent distinctiveness as opposed to a low degree of distinctiveness. So this means that the mark should be completely devoid of any inherent distinctiveness in order to be refused under the Trademarks Act. And so it's up to you to convince the examiner that the trademark possesses at least some degree of inherent distinctiveness and should be withdrawn. So let's say, for example, that, I filed a design mark of a picture of a cat, with cat food, and the trademarks office says, that the mark is not inherently distinctive. Then at that point, I may argue that, this cat design contains elements that are unique. And the illustration of the cat is one that's never been used with cat food. And so, my mark actually possesses some degree of distinctiveness. Or, let's say, for example, that my mark is a 2-word mark. I'll argue that, these 2 words have never been put together and is a novel combination, or is grammatically awkward and has never been used by competitors. I'll also review the examiner's research, since the examiner is supposed to provide you with a clear explanation as to why they're taking the preliminary view that the mark is not inherently distinctive. So if it's because they found use of your mark on the internet, then they should be providing you with the results of their research. So I'll take a look at the research and I'll see if I can refute the examiner's finding by, for example, noting that all the printouts, all the examples that the examiner provided are in fact in relation to my client's trademark. And so because the trademark only refers to one source, it's distinctive. Or I'll note that the examples that they provided, all relate to use outside of Canada. And so within Canada, it's still distinctive of the applicant. Or that the examples that the examiner provided are all third-party marks that don't relate to the goods and services in question. Or that the examples that they provided only relate to a part of the trademark, but there's no third-party websites that actually refer to both words on the same web page. And so, and even if the examiner doesn't provide you any evidence of third-party use, I would point that out. I would say, in my response that, the fact that this mark has never been used by any other trader, it's proof that my client's mark is distinctive. And it would be unfair to indefinitely reserve that mark for all to use when, in fact, my client is the one who coined it. and it's the only one that's using it. And so it should be considered distinctive. And then finally, another argument that I would note is that, if a portion of the mark has at least some degree of inherent distinctiveness, then the mark as a whole should be registrable. And then I would see if there's any case law to support my contention. So let's say, for example, that my mark is pro-sear for commercial barbecues. I would point out to the examiner that there's actually case law citing for the fact that the word pro can possess some degree of inherent distinctiveness, even though pro may be a common short form for the word professional and has some descriptive connotation. So in its entirety, the mark still possesses some degree of inherent distinctiveness. But of course, those arguments may not always be persuasive. So at that point, I may consider deleting the problematic goods and services, or maybe even filing a divisional application, as I described before. Or, I can try filing evidence of acquired distinctiveness as of the Canadian filing date, although that's kind of like a last resort after I submit at least one round of arguments.
I think we could probably talk about not inherently distinctive objections all day. Just for people outside of Canada, this is relatively new for us. I guess distinctiveness has always been part of Canadian trademark law. It probably is a part of a lot of other trademark law, but effectively in 2019, they added a ground of objection, particularly based on inherent distinctiveness. And usually we kind of paired that with actual distinctiveness, like mark can either inherently is sort of designed to distinguish goods and services, or it's just been used over time to gain distinctiveness. But in the office action context, you're really only focused on the first part of that. And it's led to some sort of a little bit of weirdness, a little bit of incompatibility with existing case law. And as Winnie pointed out, there's extensive commentary in Canada under the examination manual that can kind of help guide you through it. But it is a little bit different for us. It has been a struggle. So I thank Winnie for laying out so many different strategies for dealing with that kind of novel issue we encounter in Canada.
And Dana, not sure if you want to chime in terms of how this issue is dealt with in the US or not?
I'll add one tiny thing about something that's a little different in the US, because again, I think Winnie and David have covered a lot of ground. So in the US, the one thing that is a little different is we have two registers. We have principal and supplemental. And so a part of anyone's action plan when you are dealing with a mark like that is, well, we have the fallback position of supplemental. You always want to be on principal if you possibly can be. The supplemental register is your consolation prize. It still has a lot of benefits. If we have time for Q&A and anyone wants to ask about the supplemental register, we can go over that. I don't want to keep us from moving forward. So there is, a good reason to get it. Usually you're doing that with the thought process of, okay, we'll come back in a few years when we have some more evidence to support an acquired distinctiveness argument. We just can't solidly make that argument today. There are some consequences to getting that registration on the supplemental register though. So I would say for younger attorneys, look out, make sure that you understand what those consequences are and what your client's end goal is. So for example, if they really just wanted that trademark registration so they could get on Amazon brand registry, a registration on the US supplemental register is not going to do that for them. And if you said, oh, aren't I a great attorney? You had a refusal and I got around it. I got you a registration on the supplemental register. Aren't we all happy? And they said, yeah, but I can't get on Amazon brand registry. And that was the whole reason that I wanted this in the first place. Now I have a very expensive and useless piece of paper. It's not useless to your mind as the attorney, but it's useless to the to the client and what matters, what they think. So always make sure that whatever your strategies are, you understand the consequences and you understand what that's going to mean for the client and why they originally walked in the door.
So David, we've been discussing the difficulties posed by inherent distinctiveness, and specifically the fact that right now we're experiencing what I'll call the growing pains of these types of objections being issued right, left, and center. So when you are speaking with your clients, what's your approach for gently breaking them the news that it's quite difficult to predict the outcomes of inherent distinctiveness objections?
I think probably I distinguish between two groups. When Winnie was sort of canvassing the circumstances in which they raised these objections, she mentioned the sort of clear or mere descriptiveness and geographical locations. Those are kind of existing objections that we had before this, but now when they're raised, they're typically paired with an inherent distinctiveness objection. So in those circumstances, when you get these office actions, you can generally tell where there's a sort of a registrability objection paired with an inherent distinctiveness objection that's predicated basically on the registrability objection. For those ones, I tend to deal with the inherent distinctiveness portion of it pretty briefly in discussing with the client and just say, likely if we overcome this registrability objection, the inherent distinctiveness objection should fall away. There's another category though where they're raised independently. And the kind of ideal use case is something like contents are hot for meal delivery services, right? It's not, in Canada, we have case law that says the temperature at which goods are served isn't clearly descriptive, but that's a circumstance in which you're likely to get an inherent distinctiveness objection because that's the type of thing that a lot of people would want to put on their packaging. And those are much harder to predict. And in those circumstances, I try to, I guess, kind of three things. I try to point out this is a new ground of objection as of 2019. Two, the examiners do seem to be on different pages when it comes to raising them. The use case I mentioned is, kind of what I envision as the most obvious use case. But you see some examiners who use this as a way to basically cite common law trademarks as confusing. They'll say there's this other user who uses a similar term. So while you haven't gotten the registrability objection for confusion, you're kind of dealing with a similar confusion argument. So yeah, there's a little bit of variance in how they're raised. And then the third point is that we have no case law that directly addresses this. And to my knowledge, that's still true. I understand, a member of the federal bench has articulated a position to the contrary. But when I look at existing case law, as I mentioned, usually inherent distinctiveness is being considered in a circumstance where actual distinctiveness is also being considered, and they're often being considered in the context where there is evidence. So a court that says there's no inherent distinctiveness generally has evidence to consider actual distinctiveness at the same time. Here, we're kind of narrowly focused on inherent distinctiveness, and the case law I frankly find less useful when trying to leverage it for examiners' reports. And so those 3 points, basically, the novelty of it, the inconsistency of it, and the fact that I don't have a lot of case law to rely on if I'm really arguing it in an examiner's report, that's kind of the basis I try to cover. I find that generally helps in most scenarios. And I often make reference to if I'm talking to US counsel, to the failure to function as a mark ground to help explain it. Although from what I understand, the Canadian perspective on not inherently distinctive seems to be a little more expansive than the US equivalent of failure to function for a mark. So I at least try to kind of tie it in sometimes if I'm talking to another trademark practitioner in terms in which they would understand, with the caveat that this is still kind of new and we're struggling with it in Canada.
Winnie or Dana, anything to add to that? I couldn't see your head shaking no, but I'll assume that was in fact the case. All right, so assuming, of course, this wouldn't happen with these practitioners, but assuming that they aren't able to overcome an inherent distinctiveness objection, and therefore it might be necessary to file evidence of acquired distinctiveness, what are some of the biggest hurdles you face, and how do you overcome them? And do you have any particularly effective strategy when dealing with putting forward evidence of acquired distinctiveness? I know in Canada, just to provide some context, there are very specific guidelines that, for example, you need to provide provincial breakdown of sales and advertising figures, but certain companies, in fact, many companies don't necessarily track that information. So Winnie, we'll get your input on this particular question.
Sure. Thanks, Christy. I would say my biggest hurdle when I have to compile evidence for an acquired distinctiveness objection is when the evidence doesn't exist, or, when sales volume is, are really low, or, there's not a lot of advertising. At that point, I look at the evidence in its entirety, and I sometimes recommend to clients to wait and to refile when they believe that there is going to be substantial sales, to a point to when the examiner is going to be satisfied. The threshold is very, very high. And so you have to show acquired distinctiveness as of the Canadian filing date. So you'll want to ask the client, is there substantial sales, 5 to 10 years leading up to the Canadian filing date? If there isn't, then I would probably give them the realistic expectation that overcoming the distinctiveness objection is probably low, and then we should probably wait. But you know what, on the other hand, if there's a reason for the low sales or the small revenue, and it's because the industry itself is not very big, then I'll try to gather industry information and prove to the examiner that my client is in fact, one of the biggest players in the industry. And this type of sales volume is actually quite common. And so I'll maybe even suggest filing supplemental evidence, like an affidavit from a supplier or consumer who can attest that, they can recognize my client's mark as a trademark and as belonging to my client. This is really useful in cases where your client is a nonprofit and then they just don't have this type of revenue as, like, for example, a clothing supplier. So any information that I can use to bolster my client's evidence that is very well known, then I would put that in the evidence.
David or Dana, anything to add on that point?
I just to add about mitigating client expectations, I'm probably more pessimistic about evidence of acquired distinctiveness even than letters of consent in Canada. I think that they're probably, from what I can see, probably have higher rates of success in other countries, but I'd say very low rates of success in Canada. So you really, at the outset, you try to drive into the client to provide as much evidence as they possibly can, going back as far as they can in as many different provinces and territories as they can. At one point, I was tracking kind of acquired distinctiveness claims that were successful post the new trademark law. So post like June 2019, there was tens of thousands of trademarks advertised. I think ultimately I found about 30 or 40 acquired distinctiveness claims that were successful. So we're talking tenths of a percent. And those include non-traditional trademarks like scent marks, motion marks, which also likely have some evidence of acquired distinctiveness. But if you're talking about overcoming like a registrability objection, you're probably then looking at maybe 12 to 20 successful applications in the past 2 or 3 years. So it's really helpful to mitigate your client's expectations early on and to let them know that even if you're successful, you're going to have to prepare pretty expensive evidence sometimes, like surveys or third-party purchaser affidavits and things like that.
And I'll just add to that point, when you're dealing with clients who nonetheless want to proceed with a particular brand, knowing how high the bar is set, being proactive with telling them exactly what they will need to be tracking. The relevant date, of course, is the date of filing the application, but if they do plan on taking more of a sort of evergreening approach, if you can let them know that, tell their business people, this is what we need to track, because it's very clearly laid out, well, to a certain extent in the examination manual, then that really does help, because often it's just about creating the right Excel sheets. They have the info, they just down a couple of years later don't necessarily know how to track it. So, but Dana, I'd love to hear what you, oh goodness, we're reaching 12:59. I thought we had a little bit more time. So Dana, why don't you, you can provide any response. And our final question was just whether or not you have any parting words of wisdom on how to win that unwinnable case. So we'll lead with you.
So I will be very brief. I would say think small. Sometimes you will be given a horrible application filed by someone else, and it is just a monster, and they want to know, is there any way that this can be salvaged? And you have to look at that little Frankenstein and figure it out. People tend to get stuck when they are thinking about this in all or nothing terms. It is not always all or nothing. So sometimes your best move is to pull that little Frankenstein apart and figure out, what can you do with the pieces? Maybe you can get 2 or 3 things through, you're gonna have to discard the rest. But if you feel really stuck and think, oh my God, this is completely impossible, start thinking about it in pieces, not as the whole thing.
Yeah, and I would just say that, you know, if it's a truly unwinnable case that your client is trying to register, you know, maybe dissuade them from filing or suggest filing for an alternative. You know, the worst is that if they spend the money and it doesn't go through, you know, they would have wasted, you know, 2 years of waiting for the examination.
And I'd add that, like, in all circumstances, you should learn as much as possible about the client's products and services as you can. I think that really does guide what you can do and what's possible. And frankly, it's probably the most fun part about being an IP practitioner is that you're not doing the same stuff every time. One week you learn a lot about soap, the next week you learn a lot about HR software, then you learn about pipe fittings. Like, you get to learn a lot about where the rubber hits the road in terms of consumer choices and decisions. And that's a benefit for the client if you can throw that yourself into that. And it's enriching as a practitioner if you can do it too.
Excellent. Well, sound advice from everybody. Thank you so much, all of the presenters, for participating in this. We have hit the 101 mark, so unfortunately we won't be able to address any of the questions, but we did receive the questions beforehand from the participants and tried to integrate them as much as possible. So we hope most of your questions were in fact addressed. Thank you for participating. We hope that you continue your interest in INTA, become a member, join a committee, and we look forward to seeing you at our next event. Thank you so much, everyone.
Thank you, everyone.
Thank you.